Yes, Miss Christie.
My Lords, I'm coming on to address you now on what is required by Articles 10, 12 and 13 of ECAT. Just by way of recap, the purpose of a recovery and reflection period is to enable victims to escape from traffickers, recover from the trafficking process prior to conclusive identification, and recover prior to a decision on whether to cooperate with the investigation or prosecution of their traffickers. And we've seen from paragraph 173 of the explanatory report that it specifically refers to victims recovering a minimum of psychological stability. And for your note, that's page 621 of the policies bundle. And the court has also seen how both Article 10.2 and 13.2 require victims to be provided with support and assistance under Article 12, 1 and 2. And so I'd like to ask the court to turn to Article 12, which is at page 573 of the authorities bundle, volume 2, tab 14. So Article 12.1 requires parties to adopt measures as may be necessary to assist victims in their physical, psychological and social recovery. I'd like to draw the court's attention to 1A, which refers specifically to psychological assistance, and 1E, which refers to assistance to enable victims' interests to be considered in criminal proceedings against their traffickers. And at Article 12.2, over the page, it says that each party shall take due account of the victim's safety and protection needs. And my Lord, the Vice President in MN at paragraph 30 recognised that the intended effect of Article 12.2 was to afford victims protection from further exploitation. That's page 292 of the authorities. In our submission, there will be at least some cases in which, in order to give effect to her ECAT obligations, the Secretary of State will be required to grant a form of temporary leave to remain. I'd like to give you two examples. Firstly, it might be necessary to assist with a victim's recovery and give effect to their right to psychological assistance under Article 12.1a for a victim to be granted temporary leave. Take, for example, a victim who suffers from post-traumatic stress disorder, which is often the consequence for victims who are exposed to serious trauma, such as rape, assault, false imprisonment. They may be unable to engage with psychological therapy whilst they're in a situation of limbo, with the risk of prosecution and detention hanging over them, facing restrictions on their autonomy, which trigger reminders of their experiences under their traffickers. In our submissions at paragraph 34.1, page 104 of the Skeletons Bundle, we refer to an article published by the Yale Centre for Asylum Medicine. I'd just like to read you the quote. They say that a loss of will and ensuing feelings of fear may trigger anxiety and even dissociation in survivors, because in the past, similar situations signalled impending harm or assault. Another example falls under Article 12.1e. Victims have the right to participate in criminal proceedings against their traffickers. And it's one of the fundamental objectives of ECAT to prosecute traffickers. You see that in Article 1b of ECAT, which is page 567 of the authorities bundle. And one can envisage circumstances in which it may be necessary under 12.1e to grant a victim temporary leave to enable her to participate in the prosecution and conviction of her traffickers. A victim may not be psychologically capable of participating in the criminal investigation to secure conviction of her traffickers. if she's left in a situation where she's unlawfully present, can't work, expected to survive on subsistence level benefits, and has all sorts of restrictions on autonomy which prevent her recovery. Or a victim may just decide that it's not worth suffering the adverse effects of the hostile environment to stick around and participate in criminal proceedings. The court's already been taken to the case of Atamawan. I'd just like to ask the court, however, to turn up and look at paragraph 103 of that case. It's in the authorities, volume 4, tab 42. The case starts at 1570, but if I can ask the court to look at 1597. Paragraph 103.
Thank you.
Halfway down, we see the court saying, I would grant the claimant a mandatory order. Secretary of State use her best endeavour to secure the return of the claimant to the UK. The claimant has made it clear that she wishes to take part in further investigations by the police of her case. There should be an order that the Secretary of State grant the claimant 12 months and 1 day's leave to remain in the UK. Now, this was a case where no conclusive grounds decision had yet been made, but it's an example of one case, one instance in which the divisional court thought that it was necessary for the Secretary of State to grant leave prior to the conclusive grounds decision.
I thought there was case law that said that courts shouldn't tell the Secretary of State what to do. They can quash the decision. They haven't. They quash a wrong decision, and it will be clear from the judgment what in practice they are now obliged to do. Is it common, or are there other examples where the court has simply directed that leave be granted in a particular form?
I believe there have been, and there are other examples of the court ordering the Secretary of State to take specific steps, rather than simply just giving a declaration as to unlawfulness.
It's not constitutionally appropriate for this court to direct the Secretary of State, who has the power to grant leave. We have our duty is to declare the law and say if the Secretary's got it wrong, but we don't have the power to grant leave ourselves for very good constitutional reasons.
I'm not in any way suggesting that this court should make any similar order. I simply highlight this case an example of where the divisional court thought that it would be necessary for this individual to have leave in order to cooperate in the prosecution of her traffickers. And we accept that a grant of leave may not be necessary in all cases, but we say because of the adverse effects of the hostile environment, it will be necessary in some cases for the Secretary of State to grant temporary leave to give proper effect to Articles 10, 12 and 13, even if these are only a few cases. And there is no guidance which requires the Secretary of State's caseworkers to consider whether a grant of temporary leave may be necessary to give effect to these Article 12 obligations. Now, the Secretary of State says, and we don't dispute, that her officials can grant a form of leave, exercising the Secretary of State's residual discretion. The problem is that there's no guidance requiring them to consider doing so, setting out the circumstances in which they should exercise discretion, or the matters to which they'll have regard when considering applications, or the terms of leave. All of those things are a matter which is for the Secretary of State to decide. We don't seek to ask the court to, in any way, impinge on the Secretary of State's constitutional function. But the Secretary of State is required to issue guidance to her caseworkers. And at present, you've been taken through all of the guidance documents. They give the Secretary of State's officials the misleading impression that they should not grant discretionary leave to potential victims of trafficking in the recovery and reflection period. And in the Air Centre's experience set out in the witness statement of Director Matthew Evans, they have no experience of a victim of trafficking being granted discretionary leave in the recovery and reflection period. And the Secretary of State has provided no examples. She says, I think, in her submissions that it's always possible to make an application. The Secretary of State has claimed that there are various routes by which victims can apply for some form of leave. And we've set out in some detail in our submissions why these purported options are not practical or effective. And they don't provide an answer to this point. So in essence, my submission is that the absence of guidance alerting caseworkers to the possibility that leave may be required to give effect to Article 12, and the absence of guidance permitting caseworkers to exercise discretion to grant some form of temporary leave to victims during the recovery and reflection period means that the Secretary of State has failed to give proper effect to her policy intention to comply with Articles 10, 12 and 13. And those are my submissions on that point. I will very briefly touch on Article 4. I just want to flag, in part in response to my Lord the Vice President's question to Ms Weston yesterday, it is the Air Centre's position that an argument under Article 4 is an alternative legal route to ECAT, and it doesn't simply involve mapping ECAT obligations onto the Article 4 obligations. We set out in our written submissions the Article 4 systems duty, as well as the protection operational duty. Mr Tam did not address you on the systems duty, nor did Miss Weston. Their submissions were focused on the protection duty. We'd simply make the point that the issues arising under Article 4 haven't been fully developed in oral submissions, and in our respectful submission it may be appropriate for the court to leave it for full determination in another case. And unless I can assist the court further, those are my
Thank you.
submissions.
Anything else? Thank you very much indeed, Miss Christie. Good. We'll go back now to you, Miss Weston.
My Lords should have a hard copy of a bundle that was provided this morning, and for my Lord the MR, the email timed at 9:28 contains the electronic version of the bundle on which we seek to rely.
Very good. It's called the amended application, is it?
Yes, it's
Yeah, I've got it.
index to application for permission to amend. So this is an application to amend the respondent's notice that was filed, and the copy, I understand, is in the bundle. In May of, sorry, I've just mislaid my my aide-memoire of the timeline. In April of 2021, we see that set out in the background to the application, which is at page 20 of the electronic bundle. That was the notice which only had the part of the form ticked which related to upholding the order of the court below for other reasons. the first respondent makes her application, therefore, to amend the respondent's notice to include an application to vary the order in the alternative. So it's not to substitute the first application. We also make, as we must, under CPR 52C Practice Direction, paragraph 8, an application for permission in respect of the grounds that are set out in the two respondents' notices that the court has before it.
Where is the relief you seek now?
The relief we seek now is in the draft order
Page 32.
Yes, 32 to 33.
Right. And how does it differ from the previous version?
So,
we need to compare it, don't we, with a core bundle.
I should say from the outset that this application arises as a consequence of it not having been fully recognised by myself that one of the potential consequences of succeeding on the arguments set out in the two respondents' notices was that the court may, having determined what the law is, determine that they wanted to make a different order, not necessarily or to vary the order that Mr. Justice Mostyn made, or make an order of its own, flowing from the legal arguments that are contained in the two respondents' notices. That is to say, relating to Article 13.1, and insofar as it's not encapsulated in 10.2, Article 12, and Article 4 of the ECHR, and the public law grounds. So we see that set out in the in summary form in the application to amend, which is at page 21. So it's an unusual, in my respectful submission, position to be in, because the potential consequences of the argument partially succeeding are that the court may, in order to reflect its determination of the law, wish to vary or consider it appropriate to make a variation of the order that exists, and that is an option, a possibility which plainly the claimant would seek to adopt or to pursue if it's open to her. So I make, in essence, I'm making three applications. I'm making an application for permission to amend the respondent's notice. I'm making an application for permission to rely on those additional grounds. And I'm making an application for relief from sanctions.
Can I just ask one question, if that's all right? Is the addition you're seeking to do on page 32 just add in the bit in square brackets? Is that because looking at Mr. Justice Mostyn's order, that's the only difference I can see, is that adding in after 10.2 and or 12.1 and 2 and or 13.1, or have I missed anything out?
Well, I have to say I'm in a difficult position because one would not normally be putting an order before the court has determined what the law is. So in an appeal, in which the court has a range of options as to the orders it's going to be appropriate to make, one would normally, the court would give its judgment, give its reasons, declare what the law was, and then the parties would go away and try and agree an order and bring it back to the court, and if they couldn't agree, the court would decide. So now I don't want to bind or seek to bind the court about what form of order it should make if we are successful on the respondents, on the grounds set out in the respondent's notice.
You're slightly misunderstanding my Lord's question, and it was the question I was going to ask you too, which is how does this differ from the order that Mr. Justice Mostyn made? Now, the answer to that question is that Mr. Justice Mostyn ordered that the defendant had unlawfully failed to implement her obligations under 10.2 of ECAT to protect persons from removal from the territory of the UK after she has decided that there are reasonable grounds to believe they're victims of trafficking, because she doesn't have a specific policy concerning the circumstances in which and the terms upon which appropriate grants of interim discretionary leave may be made to such persons if they have leave to remain in the UK at the time they receive the reasonable grounds, but that leave expires, and if they don't have leave to remain at the time they receive the reasonable grounds. You're asking for something actually quite different from that, I think, which is that the appellants have unlawfully failed to implement her obligations under 10, 12 and 13
Yes.
of ECAT, or to have regard to relevant considerations, because the policy guidance fails to make reference to the circumstances in which and the terms upon which potential victims of trafficking within the MRM may be granted leave to remain, where, and then they have leave to remain at the time they receive a reasonable grounds, but that expires, or likewise as before, they do not have leave to remain at the time they receive the reasonable grounds.
Indeed, that is what we're asking for.
And the difference is in the preamble, because what Mr. Justice Mostyn said was that she should have had a specific policy concerning the circumstances in which interim discretionary leave would be granted, and you're saying that he should have said the policy guidance fails to make reference to the circumstances in which she should be granted leave to remain, full leave to remain. Well, I think.
So,
it's very unhelpful not to have an amended version.
but the amended version is at page 32, my lord.
No,
it doesn't show the amendments.
Oh, it doesn't strike out.
But
It doesn't show I see.
my Lord Justice Dingemans suggested that the square brackets were intended to show the difference. If that were right, the only difference would be that you were asking for exactly the same order, but on a wider basis, i.e. by reference to articles, a wider legal basis, by reference to Articles 12 and 13, and by reference to Article 4 of the Human Rights Convention. But my Lord the Master of the Rolls has pointed out another difference, which you can't see, unless you look very carefully, that the word interim has been left out.
Yes, and also the reference to a specific policy has gone. So what the reformulated order that you have, and I agree, it would have been helpful, and I apologise that in the short time scale that this was provided in, with reflection, yes, it ought to have had an amended order that you could see the differences more clearly. And I
don't understand what difference those differences make.
So there's what's been removed is the reference to the failure to have a specific policy. It's been replaced with a declaration in respect of the policy guidance reflecting those particular parts of it.
Is that a real difference? But can I cut to the chase as far as I'm concerned? I'm sorry if it's not what's concerning my lords. I thought this was all about a completely different point. I thought that what emerged yesterday was that you wanted to argue, based particularly on the final line of 13.1,
yes,
that if you didn't succeed on leave to remain, discretionary leave to remain, at least you would succeed on what I might call the authorisation point, which is the point we've just helpfully redeveloped by Ms. Christie. So something like the old temporary admission, which isn't leave to remain.
Well,
now, I thought that was the point, but it clearly isn't the point, because you're still asking for a different policy about leave to remain. Which of us has misunderstood who?
Well, I have to say once again, my first case is seeking a resolution of my legal argument about entitlement to some form of regularisation in the interim.
No. Your first case is leave to remain. Your first case is you're upholding Mr. Justice Mostyn's order, and that's not about regularisation. It's about leave
Yes,
to remain.
yes, that's that's the only way to regularise. I accept that. I'm in the position of having to in the alternative, our case, if the court was of the view that Article 13.1 taken with the other articles doesn't get us as far as we say it does, then yes, it would be open to the court to make the alternative order that the court's just indicated.
But that's not what you presented us with.
Well, because again, I don't want to. We put the legal arguments before the court, and it's right that I'm having to second guess what sort of order I want before I know what the court has determined the law to be, and that's put me in a difficult position. Obviously, we have our first argument, which relates to, as the court can see, if the court determined that the argument fell short of that the 13.1 didn't take us as far as we wanted to, yes, obviously we would seek an order in the terms reflecting what the court considered the law to be.
But it's not really for the court to work out the law. I mean, in an adversarial system, you say, our first submission is Mr. Justice Mostyn is right.
Yes.
Our second submission is if you, contrary to what we say the law is, say that it is only to give a form of a document, then we ask that you say you should grant a form of document, and then we've got an order that we do. It's you that proposes the drafts, not us.
Yes. Well,
I mean, the point, just to add to that, you spring all this off the last sentence of Article 13, which says, during this period, whatever that is,
yes.
the parties shall authorise the persons concerned to stay in their territory.
Yes.
And what we thought, I thought, and my lord thought certainly, was that you were going to come back with a form of words to describe what authorisation should mean in her policy. Now, you haven't done that.
Short of
Yes.
leave to
Short
remain.
of leave to remain. Instead of which, you've gone back from interim, the words, interim discretionary leave to, you've gone back to the words leave to remain. So from interim discretionary leave, you've taken that out of Mostyn and put back leave to remain.
May I turn my back just for a
Yes.
moment, my lord?
But may I just make...
Yes, my lord,
this
sorry.
is not... This is substantive. It's not procedural. It's about wanting to understand what form of authorisation, if it's not leave to remain, you're asking for. That would have had sooner or later to be put into an order.
I apologise. I did not appreciate that when the court put the matter to me yesterday. May I turn my back for a moment, please?
No.
My lord, our position is that we have never pursued just a plain authorisation with nothing else coming with it. So for instance, a line in an RG saying you're here lawfully isn't what the remedy that we sought, and we don't seek it now.
Okay, well that's very
helpful.
clear. Thank you. Okay, well I think that's very helpful. Thank you, Ms. Weston.
Does the court wish to hear from me any more on the...
No, I think it's clear on the papers, the rest of it, and we're not intending to deal with this point orally. We're going to deal with it in our judgments in due course.
Might I just make one...
But Mr. Tam will have to respond.
Yes, I understand. There are some, on the question of relief from sanctions, there are some matters set out there. We accept that it's a significant breach and the court should look at the circumstances in which it occurred.
Yes.
But we would say that this case has developed somewhat, and in seeking to focus on what has been, with respect, quite a gnomic approach to the case that
A gnomic approach. How wonderful. The case has certainly developed anyway, whether gnomically or not.
I have
I like the idea.
taken my eye off the procedural ball.
No, we're not in the business of spreading blame, Miss Weston. That's not going to be the issue.
unless I
It's
can assist.
pages 21 to 22 that you want us to take into account on relief, isn't it? I think.
That's right. Those are the submissions on the general circumstances.
Thank you very much.
Unless I can assist.
No, no, thank you very much. Yes, Mr.
May it please your lordships. Can I just give you the headline first of all? My instructions are to be neutral on this application, and therefore to leave it to the court to decide whether or not it is appropriate to allow the application to amend, given the substance of the argument you've heard and the way that the issues have developed. But may I please take a couple of minutes to make two practical points about this. The first is that yesterday evening, my team, including myself, remained in electronic contact until pretty much bedtime. I think I logged off at about 10:15 when I decided that I really wasn't going to wait anymore, and I went to bed. This morning, the first thing that I saw was that something had been emailed overnight, but at the same time I saw that we'd been asked to treat that as withdrawn because an amended version was coming. So I discarded that. I think I probably saw that maybe about 8:30, 8:45 this morning. The amended version was kindly emailed to us counsel at 5 to 10. But by then we had already had a copy kindly through our instructing solicitors because it had first been emailed to them. And I think that I saw that something like 9:25 to 10. It hasn't left us much time to take instructions. Unfortunately, we have in the event had the morning. And so I was able to give your lordships the headline version. But two things follow from that. This is not an easy case anyway. It didn't help to have it in that form. And it would also have helped if when the application, the original application bundle, as we now know, was withdrawn, we'd been told that actually all that had happened was that there was a missing document that was going to be added to the revised bundle, and we already had it. So instead of discarding it and waiting for the final version. So fortunately, that has not come to any harm because we've got an answer and I've given that to you. But Lord, it does lead on to a second and rather perhaps more important practical point. To pick up from the way my learned friend puts it, this case has developed somewhat. We would say that's the understatement of the week, but it is a feature of much of the litigation concerning modern slavery and human trafficking in this judicial review context. Because we often, on this side, simply don't know what case we're having to address and meet. Can I just ask your lordships to go to the core bundle to see how EOG's case started off?
We call this the whack-a-mole submission.
Yes. Well, it does feel.
You may well succeed in whacking this particular mole, making this particular point, but
I'm not
there
sure.
is some. The Secretary of State's position has not been exactly crystal clear from the start.
Well, I
or unchanging.
The practical point is rather than perhaps going through the documents, show you that. Yes. I mean, the point was the claim form says one thing is being judicially reviewed. If you look at the relief sought in the grounds, it's all completely different. And then the learned friend's skeleton argument for Mr. Justice Mostyn relied on purpose of the treaties, Article 12, the Residence Permit Directive, which was misunderstanding the law. I don't complain about that, and discrimination. So in the end, discrimination was rejected by Mr. Justice Mostyn, but we found ourselves at the hearing dealing with an Article 10.2 point, not pleaded. And then we come here, and the way that the case has developed before this court, the court has seen. And the point is this, that the Secretary of State, it's quite a hard-pressed unit that deals with these modern slavery cases. Anyway, they've got a lot of things to do. And we prepare cases pre-trial and in the immediate run-up to hearings, judicial review hearings, on the basis of what's in the papers. And to find it's all changed means that whatever response we give is unlikely to be fully developed, and we're often scrabbling around, making phone calls. You may have seen my instructing solicitor popping in and out all day. And then we get to a hearing like this one, for 3 or 4 days in the end. And we still don't know on paper exactly what case we're going to have to meet. I accept that the Secretary of State might sometimes be clearer. But there is a vicious circle going on here. And it's not just a practical complaint about this case. It does have an effect sometimes on the way that decisions in other cases are reached. And things that are said in other cases. And so, just by way of broad context, just give this as an example of a pattern that is developing. Having said all of that, my instructions are to be neutral on the application. And
we take your complaint, Mr. Tam, and you'll no doubt respond to some of the complaints that have been made about the Secretary of State's approach. I mean, the thing that really troubles me about this case is I was astonished by the chronology that Mr. Butler showed us this morning. And at some point, I mean, the Secretary of State really does have to, if I may put it this way, put her thinking cap on and decide what she wants to achieve with this, because it is, to use that word again, mercurial. It isn't clear. And, you know, I know you're going to have utmost clarity in your reply submissions, but that's what's troubling me, is that we see this chronology of, you know, case followed by new guidance or not new guidance, but washing of guidance, and then some more stuff, and ambiguities and so on. And that's not a satisfactory position.
And
some thinking needs to be done over in that very hard-pressed department.
Yes. Well, but again, there is a vicious circle here, because a lot of these changes are directly responding to decisions made by the courts. And I mean, I don't want to actually put it as high as this, but you can imagine it may not be far off a situation where the officials are so busy sorting out the problem that the court has just pointed out to do the much deeper thinking, perhaps that one ought to, or reflection that perhaps one being put to me as something that ought to be done.
Sorry to interrupt. I was going to say, this may all flow from the policy decision that was made at the beginning to have some in statute and a lot in guidance, because of course then we're looking back if the guidance, and I know that's not necessarily part of your case, is intended to reflect and does reflect the treaty, then of course one's looking in an unusual way in a common law court at a treaty and then pointing out this bit's missing, that bit's missing, and you're right, that causes chaos, which is why in a dualist system one normally has a statute saying this is what we take it to mean, and then you're immune from all this what you would call minor complaining.
Yes, I mean, but it would require a pretty root and branch change to the way it's been done. And, well, I mean, the court will have heard about the idea of simplifying the immigration legislation, and you know, that's not happened in many years either.
No, but this
yes,
is
well,
slightly different. This is slightly different from that. I mean, what seems to be, frankly, unclear, even in the course of this case on the Secretary of State's side, is what you're trying to do. And, you know, it's perfectly clear from what Mr. Butler showed us this morning that the Secretary of State had an unambiguous position about seeking to give effect to ECAT at early stages. Maybe produced guidance that didn't achieve that, but got a series of cases from this court which gave her guidance, but still seems to have a big ambiguous idea of what is being done by way of giving effect to ECAT, or not. I mean, it could be that at some stage I will hear that she no longer wishes to do so, but we haven't heard that yet. Certainly not in relation to Articles 10, 12, 13 and 14.
Lord, I hear the point that my Lord is putting to me, but with respect, that observation must proceed from the unspoken assumption that the policy doesn't comply with the treaty. If hypothetically, purely hypothetically now, if hypothetically the full force of the SC point were right, so that the treaty had to be completely ignored for the purposes of construing the policy and working out whether or not it was lawful. There has never been, in these relevant parts of the policy, any ambiguity at all in what the Secretary of State chose to do. For example, the grants of DL to those who are confirmed victims. The policy is quite clear about the sorts of situation, I've called them substantive situations, in which DL should be granted. And leaving aside questions of compatibility with the treaty, perfectly clear what the Secretary of State was trying to do. The rule that asylum claims had to be dealt with first, which was in version 2, no ambiguity at all about that. The problems with respect have arisen because the courts have been saying, no, this is not compatible with the treaty, and therefore the policy is unlawful, and therefore the Secretary of State must go back and revise it.
The courts haven't been saying that. The courts have been saying the Secretary of State has a declared policy to give effect to the treaty. Here is my policy giving effect to the treaty. It hasn't failed. The courts would have no right just to look into the international ether and choose a treaty. It is because the Secretary of State's policy was to give effect to it. And then if the Secretary of State has, on occasions, misdirected herself on that, then that's the job of the courts to point it out.
Yes, that's the unspoken assumption. Sorry, my fault for an unspoken assumption of where we come from, which is the high-level statement of complying with the treaty. So that's how we've got to where we are with all of this. And that is why the Secretary of State is responding by successive amendments to the policy to comply with the court's decisions. And then we get version after version after version. And the observation that my Lord puts to me, that this is ambiguous because the Secretary of State is never quite sure what she's doing, is not because the Secretary of State has been unclear about what she says. It's because although she wants to comply with the treaty, the courts tell her she hasn't, and therefore she is changing things so as to comply with the treaty. I'm shorn of legal niceties. Those are the steps. So
I mustn't take over, my Lord, but myself, I see exactly the force. Each time you're asked that you issue the rules, they're clear. It's just in some respects they've been held to be inconsistent with your policy of complying with the treaty. The ambiguity, may or may not be what my Lord is referring to, is more the ambiguity in the Secretary of State's position about whether or not she is prepared to say that she intends to comply with the treaty. Early on, that was all straightforward, but from some time, as we saw in the cases, she began to say, well, for this case I will say it, but I reserve my position for another case. And the history of this case shows the Secretary of State very unwilling to commit herself to a statement that in every respect my policy is intended to comply with ECAT. Speaking for myself, I don't know if it was the ambiguity my Lord is referring to, but that, I think, is the ambiguity that slightly troubles me about the Secretary of State's position. I mean, over several cases there's been well, I'll accept it for this time, or this concession has been made and I think we're bound by it, but it may not make it in another case, and so on. That is where I think some hard thinking is required.
well, Lord, yes. My wife is very fond of telling me that I'm a bit of a geek. And she said it again last weekend when I was describing what this case was about. And that is exactly the kind of point. It interests, personally, it interests me because it is a question about enforceability of international law in domestic law and so on. And I entirely accept my Lord's point that there is a point there that may require to be more settled than it is.
But the problem, Mr. Tam, is it's not about that. We would all be very interested, and we would love it if it were about that. But it's not about that. It is about whether the Secretary of State's declared policy to comply with Article 14 has been properly put into effect in the policy. And that is a very simple question. And my Lord is entirely right about my identification of the ambiguity. It is that we had a whole day of not knowing what your submissions were really on the subject of whether you accepted that it was the Secretary of State's policy to comply with Article 14, On Monday, Tuesday, whatever day it was, Wednesday morning, you came back and told us, yes, it was, but you reserved your position for later. And, when is later going to come? And what I was saying right at the beginning, and my Lord has said more eloquently just now, really there is now surely the time for the Secretary of State to go and do the hard thinking that is necessary so she can say unequivocally to the world and to the people who are being terribly treated every day by being trafficked and victims of trafficking and suffering immense hardship, I intend to comply with Article 14, Article 12, Article 10, Article 11, whatever it means. In other words, I intend to do my very best to give it effect in all its glory, or not. And she may not. I mean, I get the impression that she may want to say, I only intend to give it effect if it means this. In which case, that's a policy statement, fine, but you can't have it both ways. This is a cake, this is a question of cake and eating it. You can't have the credit for saying, I give effect to this treaty, whatever it means, it's a wonderful treaty and it protects victims of trafficking, and then say, but actually I only like it if it means this. And that's what's given rise to these repeated cases where the courts say, well, it doesn't mean quite that. Maybe you'd like it to. It means something a bit different. So my criticism is exactly the same as my Lord's. It's not a criticism. It's just, please, to the Secretary of State, go and do the hard thinking that seems to have been indicated as necessary in the four important cases we've been taken to. And we can't force her to, and we don't wish to, but we would point out that it would be useful if she did for the benefit of all.
Well, Lord, I understand all of that, but my Lord's observation to me started from looking at all the various different policies that get tweaked and tweaked and tweaked, and what's in them, and the difficulty of keeping up with that. Even if hypothetically the Secretary of State did have that settled position that my Lord suggests as a possibility, so that there was no longer any possibility of an argument about whether the domestic courts can simply look at the policy and say, does this comply with ECAT or not, and then make a ruling accordingly, it wouldn't have changed any of these cases, because those cases are all cases where the policy was written, everybody understood what it meant, and it was held to be unlawful. So, in effect, not strictly constitutionally, but in effect, the Secretary of State then had to change, and that's why we've got all these...
But it wouldn't have been held to be unlawful if she'd said, it is not my policy to comply with Article 14, it is my policy to do what I've written here. And that's
yes,
fact.
but even if it is her policy, and at a high level, I started by saying this, it is her policy to comply with ECAT. Where she gets it wrong, when she writes the detail of the policy, the courts will have the jurisdiction to say that is not compatible with ECAT, this is wrong, and in effect, in practice, go and rewrite it.
Well, you see, maybe my Lord Justice Dingemans is really right, as he always is. It stems from the fact that this is a funny way of giving effect to a treaty. Normally, what we do is legislate and say, this is the treaty, and we're trying to give effect to the treaty, but here's the legislation, and the legislation is what binds. And I mean, look, we've had enough of this. I think we've all got to the bottom of it. And no doubt those sitting behind you have heard what's been said and will consider it in due course. Meanwhile, you ought to reply to the submissions that have been made against you.
So, if I may then venture onto that. Can I start, please, with a few generic points? First of all, the API, the discretionary leave API, so just hold that up so the court can see, that is version 6, if it wasn't clear from what was said earlier. And that is the version that was in force at the time of PK Garner. So somebody will shout from behind me if I've got that wrong. That's why we've provided that. We'll try and make sure that we do an electronic sweep up to make sure.
So version 6 was in force at the time of.
PK Garner, the decision.
Oh yes, yes.
Also on policies, can I just clear up on instructions one of the oddities that learned friend Mr. Butler referred to today, without turning it up, because you'll remember it. After PK Garner, there was the interim guidance that was issued very quickly afterwards, a week later, and it's said to be version 1. What we understand, what we're told, is that that was version 1 of the interim guidance, and this interim guidance was only ever going to be version 1 of it. Learned friend then referred to version 2 of what's we're calling the MSL policy, which was issued in September 2018. There was a version 1 of
that.
Yes.
Well, to be fair, I think I slightly led him down that path because I couldn't work it out.
Yes.
Right.
So there was a version 1. That version 1 was published on the 7th of August.
Will you just give me a moment to write that down?
7th of August, what?
2018. So it didn't last for very long.
And it's not in the bundle.
It's not in the bundle. And that I apprehend, I haven't seen it myself, but I apprehend that is why the change log in version 2 only refers to the Scottish statute coming in. The interim guidance doesn't say anything about the Scottish statute, so it can't be right. So
it puzzled me, and that makes perfect sense as soon as you say it. It's just.
But it also begs the question as to what the change guidance said in version 1 proper.
Yes, I understand that. We haven't seen that, so I can't
think we should be provided with it, please. Because if
will.
We're going to give a judgment that tracks the history, we're going to have to be clear what the history is.
Thank you. What was the date, though, just until we get it?
Version 1 of the MSL policy, 7th of August 2018.
Thank you.
And in fact, that is probably corroborated, if the court noticed. There was a reference in competent authority guidance to the MSL policy. It gave a date of August 2018, but version 2 was September 2018, and that is a corroboration for this chronology. We'll take it out and supply that to
Thank you.
on the MSL policy itself, can I ask the court please to turn up, might as well turn up the current version, which is in Policies 4, tab 19, starting at page 1394. And within that, would you please turn to page 1407? Just want to be clear about periods of grant. The standard grant of leave periods, the first paragraph says where DL is granted for medical treatment, it should normally be for up to 30 months. And then further periods may be granted. You may regard that as renewable if that is an appropriate way of looking at that. The second paragraph then talks about grant to assist in police inquiries or for the purposes of pursuing a compensation claim. And that is normally limited to 12 months in the first instance. There is provision for longer periods of DL to be granted. And then if you look at the very top of the next page, there's it's about cases involving children, but there's a reference again to a standard period of up to 30 months. Nothing turns really on the precise length, but I draw attention to that because between that and the footnote in the report, it means that the statistics being relied on there are not really meaningful for the purposes of argument here. Some grants of DL are permissibly and rationally for 12 months or less. Other grants of DL may be for up to 30 months. And given the measurement difficulty that the footnote refers to, it's really almost impossible to know whether or not the statistic referred to has any meaning. The next point relates to prosecutions, particularly prosecutions for overstaying, but for prosecutions in any case where slavery, modern slavery, may be a factor. There is case law on this. Older case law suggests that sometimes a stay of prosecution may be appropriate if somebody is a victim of slavery. There's been a recent case, I think, about admissibility of documents. But overlaid on top of that, before one even gets to court, there is guidance to the CPS specifically on prosecutions. It's quite a long document, but clearly has to be taken account of. And it doesn't take much imagination to see how many prosecutions will simply never get started.
Sorry, but you're not being very specific. Are you saying there is CPS guidance saying do not prosecute people who are here and have been recognised as potential victims of trafficking?
The guidance is in terms that information must be obtained about whether or not they are or have been found to be victims of trafficking. And the public interest must include consideration of that. I don't think, we certainly haven't found any specific yes, no, you must not.
It's very peripheral and not sure it necessarily covered. But I mean, since you've referred to it, is it a public document?
It is. It's published. And we can provide. Well, we'll provide the link, and we'll provide a print or electronic print of the guidance. But the point really is that so far as overstaying is concerned, and the criminal offence of overstaying, if somebody is a victim of trafficking, or if they're a potential victim and they're protected because they're irremovable, and the Secretary of State's policy says they can't be removed, the reality is the prospects of a prosecution or even any serious investigation into that are negligible, perhaps even less than that. So that really isn't a factor in this case.
Well, it is and it isn't a factor, because there is something called security. And this was a point that Miss Christie made quite eloquently earlier today. That, it's all very well to say, for people sitting in this court who are trained lawyers, it's absolutely fine, you won't be prosecuted. But if you're a vulnerable victim of trafficking who's just been through, without putting it too unsubtly, hell and back, and you don't know that is the case, actually somebody telling you in a letter, dear victim of trafficking, you will not be removed, you are safe and secure in your home, is something that can probably add to welfare considerations, can't it?
That I would entirely accept. And if the letter doesn't say that, it could easily say that, because that just sets out the position.
I think the decision letters make it clear that they can't be removed until the conclusive grounds bit. It certainly refers to.
Yes, sorry, I've forgotten the exact text. We did.
It might also say, and you cannot be prosecuted, because the terminology has changed. I mean, it used to be that the terminology was the rather user-friendly terminology of temporary permission.
But can I come to that separately? Because there's another point where we would take serious issue with both my learned friend Miss Weston and my learned friend Miss Christie.
What, on illegal bail?
On temporary admission. Temporary admission.
No, I'm not talking about temporary permission. I'm talking about the new terminology of immigration bail.
Well, both, because it's the same. But I'll have to come to that because it's a topic on its own. We entirely understand that insecurity is something which could weigh on people's minds. But there are two distinct concepts that one has to remember. So far as the EOG situation is concerned, we are talking not about longer term security. For example, am I going to be here long enough to complete my medical treatment, to have enough therapy, counselling and so on, before I'm removed or before I'm told to go home and have that at home. And one can see that a sense of security in having the, say, familiar or the already started treatment here may be good. But so far as the EOG situation is concerned, the security that could be conferred by DL is limited in principle to the conclusive grounds decision. And when that's made, that comes to an end.
So in a sense, to paraphrase, it just has to be faced that your position as a potential victim of trafficking is insecure, whatever bit of paper you get. The only real substantive promise you can be given is you will not be removed. Because the conclusive grounds decision could come tomorrow and be against you. You may or may not have an asylum claim, in which case that's a separate point, but your asylum claim may or may not be successful. But until you have a positive conclusive grounds decision, of course even that doesn't give you any long-term right to remain, and a successful asylum claim, your position is inherently insecure.
Exactly.
And whatever you may say around the edges, you can't conceal that, and people will feel insecure for that reason. That's your point?
That's exactly the point. That's exactly the point. And DL does not add to the irremovability that already exists in that period. I accept maybe it could be more clearly communicated, but as a matter of law, the DL doesn't add to that. What learner friend Miss Christie was really contending for when she was talking about the consequences of having leave is the kind of stability and security that comes from a grant of leave that is not necessarily tied just to the conclusive grounds decision, and also, in addition, necessarily comes with the additional rights to which she refers. So, for example, to mainstream benefits, which I understood to be part of the submission. And we respectfully say that that is taking a leap too far, because there is absolutely nothing in the conventions, or ECAT, that suggests that all of those additional things must come. I mean, remember, the baseline is that once you've got an RG's decision, you've already got all the support and financial support, material support, treatment. So that's one of the reasons why I showed the court that when I opened the appeal. It's all already there. And so if it's not just a grant of leave until CG's, longer term grant of leave, and if the stability and security only come not just from the leave, but from all sorts of other things that come with it, like mainstream benefits, then that is asking for a lot more.
Well,
than ECAT
can I just be clear about this? I forget whether there's been a reference to mainstream benefits, but the position must be, I think this is the point you're making, discretionary leave can be conditional, and an absolutely standard condition, not always made, but is leave without recourse to public funds, other than what you would have as a victim of trafficking. And you say that there's nothing in the enhanced protections which gives you access to any particular level of benefits. I think that's right, isn't it? But I have thought the focus is more on the right to work, which of course is qualified, but is there. Have I?
Yes. Well.
Firstly, have I understood correctly what your position is, that even if you are given discretionary leave, it is a matter for the Secretary of State to say whether that is Secretary of State, whether that is discretionary leave with recourse to public funds?
What I say is this: if you're given discretionary leave in accordance with what's set out in the policy, and in the circumstances that the policy contemplates, and leave aside questions of compatibility, then you get what the Secretary of State intends to give you in those circumstances, and that may include benefits, it may include the right to work, and so on. The problem, what I'm trying to identify here, is the problem with the submission that is being made about security and stability, which is that it is premised not only on you getting a grant of permission to stay in the UK, which is what leave to remain is, but a whole raft of additional things which would normally come with discretionary leave under the Secretary of State's policy granted to those who are established victims. that is what. Forgive me.
Well, sorry, since you've been interrupted, I haven't just done. Are you saying that under the policy as it is, if on her criteria the Secretary of State decides to give you discretionary leave as a confirmed victim of trafficking,
Yes.
she doesn't normally say, she doesn't exclude recourse to public benefits, to public funds, whatever.
Yes. Normally.
So normally you get benefits and the right to work. But that's her choice, isn't it?
Well, and she's not complaining about that.
No, I understand, but it's what I'm comparing what she gives with what the convention requires.
Yes.
I see nothing in the convention that would require you, in those circumstances, to be given access to mainstream benefits.
No, that's right. I mean, that is a policy choice. When
Yes.
if you get there,
And I'm sure it's a good policy
yes,
choice. Don't
yes.
get me wrong; it's not for me to say, but I'm not saying you shouldn't be making it. I just want to understand conceptually that that's going beyond what the convention explicitly requires.
Yes. And the problem with the stability and security argument is that when you unpick it, and both Malone and friends are perhaps understandably coy about exactly what they say should come with this grant of leave to remain. When you unpick the argument and go into what it is that's being suggested will give the stability and security, it is not actually just the leave itself, nor is it just the leave itself for that strictly temporary purpose until conclusive grounds decision. It's a longer term leave, and it should come with other things. And it's the combination of all of that that would give the stability and security. Now, obviously, it would not be a breach of the treaty for the Secretary of State, a Secretary of State, to say we'll do all of this. But this illustrates one of the problems with the arguments that we are constantly faced with in these cases, which is that these are actually policy arguments. They're perfectly proper policy arguments. Victims of trafficking, potential victims of trafficking, ought to be treated more generously than they are because there are some benefits. And then on the government side, well, it's not just the Home Secretary who's got to look at it. There's a whole cross-government policies and considerations that need to be taken into account in formulating them. So the stability and security argument actually conceals the fact that there are some very deep waters here. It's not a proper argument, we respectfully say, to run once you look at the situation which is actually a consideration in the individual case, which is a potential victim of trafficking who is waiting for their conclusive grounds decision. And that's why we respectfully say that the stability and security argument should be rejected. Otherwise, what you get is a situation where somebody's got a positive reasonable grounds decision, they're a potential victim of trafficking, there is a credible suspicion that they have been trafficked, and then immediately, if you go down this line, they get all the benefits of lawful residence and residence permit under Article 14. Not even Article 14 says that this is what should be done. From that, I was going to go on to a...
But it is said against you that Article 13 does.
Well, no, after the recovery and reflection period, as I understand the argument, it is a development of what's in 12.1, which is the general requirement to assist potential victims.
It's a development, but it requires, I haven't got 13 on my screen, but I can get it. It requires that the parties shall authorise the persons concerned to stay in their territory.
Again, can I come back to that, because we do have a submission to make about that last sentence of 13.1. Yeah, sorry.
Well, I mean, the last sentence of 13.1 is what this case is becoming about. Certainly part of it. Yeah. Okay.
Yes, well, which is why, if I may come back to that specifically. But can I? Well, actually, as my Lord mentions, as I'm going to ask the court to look at the treaty itself anyway, let me do both of those now. The authorities, tab 14, page 573. 3.
We should be able to recite it shortly.
This is the list of things which must be provided both to potential victims and confirmed victims, established victims. 12.2 doesn't add anything to that. And then 12.3 and 12.4 are only benefits for people lawfully resident in the territory.
Yes.
Common ground, that is equivalent to having a residence permit.
Yes, if you don't already have some other lawful residence here, and that includes education. And so when learned friend complained that the current letter doesn't give you anything to take to a place of education to show that you're entitled to it, well, the short answer is you're not. You're not entitled to it because a potential victim doesn't have the benefits of 12.4, and so there's no.
I accept that's the position under the treaty. My misunderstanding was that the Secretary of State was more generous than the treaty and provided educational opportunities to PVOTs between RG and CG. Is that right?
No, the short answer is that what the policy says is that if you already have the right to be educated, you can
continue
use that. It doesn't confer an additional right. So there isn't actually a need for a potential victim to show a reasonable grounds letter to establish a right to education, because there isn't one. Finally, on generic points, can I just say something about the possibility of the court concluding that the policy should be read down in a similar way to Article 3. I know logically this comes maybe right at the end or at the relief stage, but can I just mention it now? Because learned friend Mr. Butler showed you how one sentence in the MSL policy was quashed, but it took some months for the next version of the policy to come through. Now, just on a purely practical level, one can see the potential for misunderstanding or ambiguity there. One of the things that I would be concerned about if the conclusion of this court were that a policy that says one thing on its face had to be read down so that it actually means something else, because that would be dangerous when a caseworker, for example, not a trained lawyer, looks at that. Where we've got statutes being read down, well, generally it's going to be looked at by lawyers who have access to the case law and materials that show.
In general terms, I absolutely get the point. But that episode shows that you're perfectly capable, presumably, I probably don't know, but one must assume that during that 9 months or 6 months or whatever it was when the policy went uncorrected, nevertheless caseworkers were told, ignore that bit because it's been quashed by Mr. Justice Murray. And if we were to say this, although it appears to read like this, can be actually compliantly read to read like that, instructors in caseworkers will be told that as well.
Yes, certainly.
It's not ideal, but it's just it's the same problem really. Whether we quash it and you have to rewrite it, or we say it means something different from what it looks like at first reading.
Yes, I entirely accept that it is possible to give the guidance that would help. I think the practical point is that if the policy is actually rewritten because it's been quashed and has to be rewritten, then that would be a less dangerous way of dealing with it than to have it in place but meaning something other than what it says. But as I say, this is a very practical point, but it flows from the discussion that Lord had with learned friends at points during the argument. Can I then, I'm sorry, having opened the treaty, I've forgotten to deal with Article 13.1. While it's still open, can I make a submission about that? 13.1, as I observed in opening, is not clear about what it's all referring to. If the EOG case is going to turn on this, then I think that what I should do is to make an observation that it is inherently unlikely that the last sentence of 13.1 refers to the same period as the first half of 13.1, or indeed the 10.2 period. Because
hang on
both...
a second, sorry.
Sorry, but both...
Sorry, you go on.
Yes, but both 10.2 and 13.1 are written, or sorry, 10.2 and the first half of 13.1 are in negative terms. And it is inherently unlikely that the drafter would then go on to express a positive obligation about exactly the same period. And the second point is that if you look at the two halves of 13.1, it does refer to two conceptually different periods. The first is the recovery and reflection period, and then during this period, that naturally refers to that. And then the second half, starting this provision, refers to what is conceptually a different period altogether. And then the natural reading of the
Well, it doesn't really refer to a period.
no,
It refers to activities.
It refers to activities, but they're going to be carried out over a period, and we know
Well,
how.
Well, logically, that is no doubt so, because activities take time. But the point is, that A, this sentence that starts this provision is only it's a parenthesis. It's a without prejudice point. And secondly, it doesn't refer to any period at all explicitly.
I accept that. But then, of course, if the drafting had been clear, we wouldn't be having this argument at all. And one could put parentheses starting this provision and ending at the end of 13.1. Then that would make it much clearer.
Well, I mean, I don't think it's all that complicated. I mean, it says the provision is without prejudice to certain things. The activities carried out by competent authorities in all phases of the national proceedings, and in particular the investigation and prosecution of offences. During this period, i.e. the period during which they're doing those things, namely relevant national proceedings and investigating the property. I mean, it seems to me that that's a pretty obvious.
Well, if I may respectfully and gratefully adopt that, that is what we say is the most likely reading of that, because any other way of looking at it just introduces all sorts of...
Well, I mean, the contrary argument that both, I think Miss Weston and Christie adopted was that during this period must refer to the entire recovery and reflection period.
Yes, well,
But I mean, but as you rightly say, it's inherently unlikely that you use during this period in the same article to mean the same thing when they say different things.
That's right.
I mean, it would be unusual drafting even for an international treaty.
Yes.
I mean, that's it, isn't it?
Yes, that is it. And if the drafter had been intending to refer to the same period, it wouldn't actually have used two sentences starting during this period.
Well,
within
So
I'm
what
not
do you
sure
say
about that.
during this period in Article 13.2 means? Which is that? Is that yours and the Master of the Rolls' second one, or the first one?
that is the first one.
Why?
Why? Because of the reference to 12.1 and 12.2, which is the period, which are the obligations owed during that recovery and reflection period, i.e. between reasonable grounds and conclusive grounds.
Yeah.
So at the beginning of 13.2, that must refer to the first half of 13.1. I mean, it's a matter of speculation, but it may be that having done that, somebody said, oh, well, we ought to have a provision in here about criminal investigation and prosecution before the conclusive grounds decisions. Let's stick it in here. But
I mean, I bet you'd find in a foreign language it wouldn't, first of all, say during this period, and
Well.
you can see that even if it does, you can see from 2 and 3 Article 13(2) and 3, and the heading to the article, that the beginning of 1 and the beginning of 2 and the beginning of 3 are all about the recovery and reflection period, because that's what the article's about. And they've tagged on another idea, without prejudice, in the second, what you call the second half of 1. But I mean, that's not free from doubt, just the way I read it.
Do we know what the official language is for the treaty word?
No, I was just.
I mean, we've got the Travo in the sense we've got the explanatory notes, but I just wondered if we had anything more.
I couldn't immediately. I've just been looking at it while
Page 592.
Sorry, page.
Page 592, last paragraph.
590.
592.
In the authorities bundle.
Yes, sir.
Thank you.
$5.9.
In English and French. Both equally at work.
That, of course, is inevitably the page I'm missing.
Well, it just says the two authentic versions
Yes.
in the English and the French.
I'm grateful.
I would lay not a great deal of money, but some, that the French will use exactly the same phrase, whatever
Yeah,
it happens to be,
absolutely.
for each of these during this periods. So I don't.
We'll have a look and
You can add it to your electronic bundle.
we'll do that.
Thank you.
But before we, it was said, and I've now forgotten exactly which paragraph. It was said, I think, by Ms. Christie or Ms. Weston or both, that their reading was supported by the explanatory report.
Yeah.
I think it is, again, our old friend 178.
178, yeah.
Yeah, well, that's pretty explicit. I appreciate it's not the treaty. It does say during the recovery and reflection period. But here's another possibility. Look, really what we're concerned with here is non-expulsion. But two different concepts are slightly mixed up. 10 is the process of finding out whether someone is a victim or not. So there's an interim period between reasonable grounds and interim grounds. And there, in that context, a different article, maybe a different draftsman, you have the phrase of shan't be expelled. Recovery and reflection period, it's become increasingly clear, is really just another aspect of the same thing. Certainly in English practice, UK practice, it is. The whole period between the reasonable grounds and the conclusive grounds is treated as the recovery and reflection period. I suspect the draftsman, if he thought about it, would have had to realise that was necessarily so, because what else is the status during that interim period? The draftsperson there talks about to authorise, but perhaps they're only meaning the same thing as the draftsperson of 10 saying shall not be expelled. The only perhaps difference is that it has a flavour, which the explanatory report picks up, of getting a bit of paper that tells you you're not going to be expelled.
Well, certainly that would be the alternative submission, which is that it is
And
not as far as granting a residence permit.
Yes, well, yes.
But it's
Contrary to my argument, I suppose, is the non-expulsion does appear in 13.1 itself.
So that's why.
Okay, well that weakens my point. I'm not sure it completely destroys it.
I'm not sure that we can ever conclusively find the answer.
I remember we grappled with this, although in MN, and didn't get to the end of it. Unfortunately, didn't have to.
And the submission I make, the alternative backup, that's, I think, what I need to say about that.
But
So
what is the status of the explanatory report? Do you, if one were clear, say, one judge were clear that the proper construction, with taking all purposive indications into account, was what I put to you, and the explanatory report says it's different, what's the answer?
Well, the answer, and going back to 178, although I accept that the phrase there is relevant documents authorising them to remain on its territory, that does not necessarily have to flow from the last sentence of 13.1, because this is referring to paperwork rather than a positive administrative decision. So that would be one way of squaring.
Yeah, but that doesn't deal with the point that 178 explicitly identifies the period as being the period of the recovery.
Yes, that's what I mean. That,
I see.
that 178 is talking about the first half of 13.1, and while the last sentence of 178 does have the word authorising them, that's not being used in the same sense as the last sentence of 13.1. That's it's a possible way of squaring that. But ultimately, the explanatory report is not definitive. It's not a definitive exposition of the meaning of the treaty. It is a guide, and often a useful guide. But it couldn't resolve this, and 13.1 itself is rather odd.
The risk of going on about this forever. If the point were properly before us, and it remains to be seen whether we will think it is properly before us, what would you say about a finding that it questionably doesn't give leave to remain, but it does require, to use the language of 178, a legal framework which allows them to remain, evidenced by proper paperwork, effectively requires you to ensure that everybody, instead of just somebody, is covered by immigration bail paperwork?
With respect, no. Because I'm going to come on to that. Immigration bail, temporary admission, temporary release are not forms of authorisation to stay of any sort.
Well, they're not in UK terminology, but they might well be in convention terminology, and they do authorise you to stay in this sense, that they say you can't be removed.
All that they do, sorry, I'll come on to the detail of this, all that temporary admission and temporary release and immigration bail do is that they authorise you to be not in detention. That's the function. It's not any form of immigration status at all. It never has been.
You'll make it more difficult for yourself then.
I'm sorry.
You'll make it more difficult for yourself, because I'd have thought the Secretary of State could live with a halfway house, whether or not ultimately we can direct this, and whereby you create a bit of paper which, if it isn't exactly like immigration bail, is quite like it, like temporary admission if you prefer, saying that you can be in the UK until we make up our minds what to do with you.
I shouldn't take up a bad point just for forensic advantage in one case, because I having litigated some of the temporary admission litigation and the immigration bail litigation, I don't want to wreck the structure of how it works in those cases.
No, I see that, and you're quite right. These are very technical, and you don't want us blundering in and suggesting a solution or imposing a solution which messes up everything else. So I don't criticise you for correcting us, but conceptually, it's quite clear you say this doesn't require you to give leave to remain, and assume you've won on that. So you have, but assume you have. But that we remain troubled, that there is no paperwork covering your status in this interim period. What does the Secretary of State say about the alternative argument that there should be some such paperwork, whether or not it's exactly like temporary admission or immigration bail?
Well, I think, there are things on which I would have to take instructions, but I think I can probably say this at this stage, that if the paperwork that is given to somebody with a positive reasonable grounds decision says, because you have a positive reasonable grounds decision, you are protected from removal against the UK, and you will not be made to leave the UK until at least you have had your conclusive grounds decision. That is something which I can't for myself see any objection to something like that going in to the paperwork.
I suppose you're also entitled to say that there is expressly, on Miss Weston's case, no respondent's notice asking for that minor relief.
Yes,
Well, that's why I said if this point is open to us.
And the French version does use the same phrase
Which is?
Pendant ce délai.
Lords, those were the generic points. May I try and rattle through the substantive replies as quickly as I can. The first point to make, which it's now slightly inchoate because of the application to amend the respondent's notice and to suggest different forms of relief. But it is to do with looking carefully at what Mr. Justice Mostyn decided was the legal obligation, because that was very different from the sort of thing which is now being contended for by my learned friends Miss Weston and Miss Christie. Can I invite the court please to go to paragraph 48 of Mr. Justice Mostyn. It would be in the core bundle at page 105. You see that what he's referring to is what he held was the obligation to protect persons in receipt of a positive reasonable grounds decision from removal. Expressed in those terms, that is all people with a positive reasonable grounds, that's say all PVOTs. And then he says, suffering such persons remains overstayers or as illegal immigrants does not fulfill the obligation. So clearly he is thinking about everyone who has a positive reasonable grounds decision. And then he says that what we must do is formulate a policy that grants such persons interim discretionary leave on such terms and conditions as are appropriate. It is not for me to prescribe what such terms and conditions should be. So what he is clearly contemplating is that everybody in this category will be granted leave, and what the Secretary of State has discretion to do is to set what the terms and conditions are. Now, I accept that the actual declaration in the order is in slightly less specific terms. But clearly, if a question thereafter arises as to whether or not the Secretary of State's new policy complies with the law, it would be to paragraph 48 that everyone would look. And so if the new policy does not grant leave of some sort, some terms and conditions, to every PVOT, then it would be in breach of what Mr. Justice Mostyn had held to be the law. So that is what he found. And we respectfully say that nothing in the argument has come anywhere close to demonstrating why there is an obligation to do that. I'm not going to go back through all of those arguments.
No, you also say the last sentence of paragraph 41 is wrong. About the final sentence of Article 30.
Oh, yes, I do. And I think Mr. Justice Linden, when he looked at the same point, was very politely saying that he wasn't sure he agreed with Mr. Justice Mostyn on that.
Do you know which paragraph that is, just for my note?
102, core bundle 322.
Which paragraph?
Paragraph 102.
Yeah, that is polite.
What learned friends are contending for now appears to be something very, very different, which is that of the whole cohort of PVOTs, there may be some who ought to be granted some form of leave on some terms and conditions, and the problem is that the policy ought to make some allowance for that. It's a radically different case from Mr. Justice Mostyn's decision from which we are appealing.
I think Miss Weston's her first point was that Mr. Justice Mostyn was right for the reasons he gave, and that was a fallback position, as it were.
Yes, I accept that, but my response to that is what I've already said, and this, perhaps if it's an alternative case, we say it's a radically different case, and it would involve considering radically different matters as to whether or not there should be some corner of this cohort where it ought to be possible. Of course, it is always possible, if there is a really needed case, for a grant of leave to be made, because the Secretary of State has a residual discretion to do that. But we invite the court to reject it fundamentally on the same basis that during this period there is no obligation imposed by the Convention, by ECAT, to do this.
No positive obligation.
No positive obligation to grant leave. The second thing that I was going to say was to make observations about these being, or many of these arguments being policy arguments. I've done that, so I'm not going to do that again. The third one is to do with temporary admission. On this, I hope that your lordships have another clip of extracts from the Immigration Act, show you what temporary admission was all about. The first page of this starts with paragraph 16 of Schedule 2 to the Immigration Act in the last form it was in before it was abolished on the creation of immigration bail. I'm sorry, in fact, sorry, paragraph 16 is still in force because this is actually the detention powers. And you see that there are a number of different situations in which somebody could be detained. Going on to what I think is the fourth sheet of the bundle is paragraph 21. This has now been replaced, or repealed anyway.
Is this section 21?
Paragraph 21
of
Schedule 2. And 21.1 provided that a person liable to detention or detained may be temporarily admitted to the UK without being detained, or, insert a word, or may be released from detention. But this shall not prejudice a later exercise of the power to detain him. So there you see that TA is not some form of immigration status, it's an alternative to detention.
Well, all right, but it's not some form of immigration status in the sense that we recognise, in other words, it's not some form of leave to remain of the kind we know from Section 3 of the Act, but it is temporarily admitted to the United Kingdom. Now,
yes, if your lordship would just bear with me, I'll come on to that. But the temporary admission can be on conditions, as well known. And we respectfully say the only way of looking at this, and it's always been looked at, is that temporary admission is a form of control of individuals who are, the vast majority of cases, I think, seeking to enter the UK as an alternative to detaining them while their admission is being worked out. If you can then go on, please, to section 11. The first appearance of section 11, which is, I think, another 3 pages on. It's the one that has the mark superseded. This provides for the meaning of the obstructionist references to entry and other phrases. And you see at 11.1, the person arriving is deemed not to enter unless and until he disembarks. If he's disembarked at a port, shall be further deemed not to enter the UK for so long as he remains in such area as may be approved. That covers your walk from the plane to the immigration desk. And a person who has not otherwise entered the UK shall be deemed not to do so as long as he is detained or temporarily admitted or released.
and that's consistent with what I put to you, isn't it? That's why he doesn't need leave to enter, because he's deemed not to have entered.
Yes, but the statute specifically provides that he is legally in the same position as somebody who is, for example, standing at the border control point, being interviewed by the immigration.
I see that. I see that.
So being granted temporary admission is not a form of admission to the UK in the,
Form
in the
of
same sense of
non-admission.
Sorry.
It's a form of non-admission.
Yeah, exactly, exactly. And then if you go on, please, another couple of pages, the current version, you will see that the change to 11.1 is that the reference to temporary
If
admission...
you were temporarily admitted, you were committing a criminal offence, were you? Under whatever section?
No, because you wouldn't have entered. Deemed not to have entered, I think is the answer.
Regardless of the reality.
Yes.
Yeah.
I mean, again, we know people are
That would
well
solve,
on
that would
TA
solve
for
the
years.
criminal offence problem. Anyway, yeah, okay.
But if you look at 11.1 in its current form, you'll see that there's been a direct replacement for temporary admission of the concept of immigration bail within Schedule 10. So immigration bail, as obviously a form of control short of detention, does exactly the same thing as temporary admission used to do under the old scheme.
So where do we see that? Sorry.
It's the second version of Section 11,
So I see.
the law in force.
But from your point of view, it's just enough to say different label, same concept.
Exactly, exactly. So learner friend submissions that TA and TR was some better form of status than you get now. It is with respect not right, because when you look at what temporary admission was, you get the nature of that. And to nail what I hope is the final nail into the coffin of that, can I invite you please to look at Schedule 3, which is in the authorities bundle. It will be bundle 2 at page 675.
675.
675. Schedule 3 concerns deportation. Now, this is the current version of Schedule 3, but deportation is the context in which somebody might be temporarily released when temporary admission, temporary release are being used as
So
two.
sorry, I've got behind. Where on
Yeah.
the page are we? Which
Authorities, Volume 2, page 675. It's under tab 17. At 675, can I just identify there's a reference there to immigration bail, where somebody's been recommended for deportation. In subparagraph 2, top of page 676, there's sorry, that's another detention power. I think I've skipped over a logical step, but the first three subparagraphs here are all detention powers or provisions for detention. And then at the last three subparagraphs, now 5, 6, and 7, you see that references to immigration bail, which obviously gets you out of detention. Where there's a reference now to immigration bail, there used to be temporary release under Schedule 3. We haven't got the original versions, but that's where it came from. And the point to make about this is that you can be deported and subject to all of these provisions, now immigration bail, formerly temporary release, even if you had leave to remain, and even if it was indefinite leave to remain, because you might hold leave, extant leave, but be subject to deportation. And that, we say, conclusively shows that temporary admission, temporary release was never some form of immigration status in itself. It was always only a matter of control of people who were subject to immigration action of one sort or another, and it ran entirely parallel to and conceptually separate from immigration status.
May I just ask a question about the final sentence of Article 13 again? If you are, under the old scheme or the new scheme, deemed not to enter the United Kingdom, and if this period refers to the period while you're in recovery, how is the United Kingdom authorising the person to stay in their territory when you're deeming them not to be in the territory?
Well, it may be that for the purposes of the convention, they're in the territory, which physically they are. The ECHR has the same, or our ECHR obligations have the same concept, that they're in the territory and they're not going to be removed. So they are, in one sense, authorised to stay. So there's no inconsistency there from that.
Thank you.
So I've just been slow about this. Under the current arrangements, a potential victim of trafficking who is irremovable under our policy it's straightforward. They have no, obviously they have no, unless for some other reason they happen to have leave to remain. They have no leave to remain, so they have no immigration status in that sense. And they may well not be on immigration bail or have been on temporary admission or release. They may have been none of those things. So what are they? They're just illegally present, or whatever
Yes,
to use.
In theory, they might just be legally present with none of the immigration control powers having been exercised. But for the purposes of ECAT and the Secretary of State's policies, they're a PVOT, they're irremovable. That, we say, satisfies the non-expulsion obligation.
They're irremovable because what is their legal irremovability status under English law?
The Secretary of State has a clear policy. Nothing else is clear. This is clear policy that they won't be removed.
Until they've got the conclusive grounds, etc.
Yes.
It is their irremovability consists in the fact that the Secretary of State has made a policy statement to which he could be held by judicial review, not to exercise the power of removal which he unquestionably has under our immigration scheme.
Yes, as
It's
a
just that.
absolute minimum. That is conclusively a legal route to enforcing non-removability.
Something you say would never happen anyway, because of
No, it wouldn't. This all
No, but she's entitled to know that the irremovability is legally enforceable, even if, my Lord says, in practice the Secretary of State would never do it because she knows contrary to policy, but mistakes sometimes happen.
Yes, yes.
In the case of such a mistake, the status of irremovability would be enforceable. And you say that's all that's required by 10.2 or by 13.
Yes. And if the asylum system were similarly on a policy basis rather than in legislation, exactly the same argument would run. It would be exactly the same position.
I think there was legislation about the asylum system.
Oh yes, the asylum system is
In the
enshrined in
immigration rules,
legislation.
isn't it?
Sorry.
Where does the asylum system come? In the immigration rules, which are themselves not.
No, but irremovability, I think, is now in the two.
Oh, that is statutory.
Yes.
Sorry, yes.
But hypothetically, if the asylum system were given effect entirely by policy, then the legal route to irremovability would be the same. Well, one imagines.
But it's not.
But it's not, because it is statutory. So. I'm using it to test the viability of the point I make.
So the position of an asylum seeker could be, apart from the fact that irremovability is statutory, could be identical. That's your point.
Yes, yes.
Because they might not have any form of leave to remain. And they might not have immigration bail. Probably would have by one route or another, but they're not required to.
I mean, I would have thought that once an individual has come to attention, it's overwhelmingly likely that the immigration powers would be enforced. But in theory, yes. Sorry? but that's because that's to show that they're an asylum seeker. Oh, they've got a document. Yes, learned friend is pointing out that in the asylum system, an asylum seeker does get a document in the form of a card, plastic card. Yes, credit card size card. Yeah, showing they're an asylum seeker. So there is documentation there.
What does it say on the card?
Well, I don't know because I recall having seen copies of them, usually bad photocopies, and I can't recall what's written on it. As Learned Junior's found a description of the ARC card on gov.uk. It includes a paragraph. This includes details of their nationality, as well as age and whether their age has been disputed by the Home Office. The ARC certifies that its holder is an asylum claimant and as such will be allowed to remain in the UK while their asylum claim is still pending. So, as I said, I can't remember what's actually on the card itself.
Well, I've got some up on Google. I just would need to get the right one, but yeah, there's loads of them.
I'm grateful. There are definitely pros to having the technology in front of you. Lords, the fourth point I was going to make on this was the insecurity point, which I've now dealt with. The fifth and final point on EOG relates to Article 4. And the case of VCL cited by my learned friend Ms. Weston. My Lords will have noted, I'm not going to ask time now to make the submission itself. Lords will have noticed that the case does not mention a grant of leave to remain as being one of the obligations imposed by Article 4. I think the way that learned friend Ms. Weston put it was that if Article 4 maps across the Article 10, Article 12, Article 13 obligations, and if that's right, then of course it is only those negative obligations, and there's really nothing more from Article 4 that would help EOG on that. That's, I think, all I need to say in reply on that. That's all I need to say in reply on EOG. Can I then turn to KTT? One point which not going to be the determinative part of this case, we checked the position about the 23rd of February date for the appeal in the FTT. Our understanding is that it is the substantive hearing of the appeal, but this is getting it from, as I understand it, us phoning somebody in the Home Office who phoned the FTT to ask, and the FTT said that it is a substantive hearing. So I think we'll have to just leave it as at least some room for doubt as to what's going to happen in a couple of weeks.
Well, it strikes me that both of you ought to liaise and discharge your duties under the upper tribunal rules to cooperate and work out you have an effective hearing, whatever it's for.
Do you know when that happened? Okay. Apparently, KTT's side applied a couple of days ago to convert that hearing into a case management hearing, and that is the way things are.
That doesn't undermine the point that both of you ought to be talking immediately.
We really ought to find out what happens, and it may be that will include whether the tribunal accedes to the request. Before launching into the point-by-point reply, can I just ask the court to remind itself of what was being sought by KTT from Mr. Justice Linden? It's another variation on the cases changing all the time point. This is Core Bundle page 295, paragraph 5 of Mr. Justice Linden's judgment. He says, 5.1, he says, the way in which ground 1 is put, has undergone some refinement. As expressed in the claimant's skeleton argument, ground 1 alleges that the MSL policy is contrary to Article 14 of ECAT, quotes, because it fails to permit the grant of MSL to a victim on the ground that she has to remain in the UK to advance an asylum protection claim based on the fear of being re-trafficked. On this basis, the refusal of leave in the claimant's case is said to be inconsistent with Article 14(1)(a) and therefore unlawful. So this is not a claim, or by the time it reached Mr. Justice Linden, it was not a claim that because there was going to be a long time before the resolution of the asylum and KTT, for example, had a need for medical treatment for which she needed discretionary leave, that she should be granted discretionary leave. For that matter, it was not a claim by this stage that, for example, she needed leave because she was helping police with their inquiries. This was put on the basis that it was leave in order to pursue her application for leave as a refugee. And that is the entire framework within which we have constructed our appeal. During the course of Learned Friend's submissions today, he was trying to, it seems to me, broaden this, broaden the case to embrace confirmed victims of trafficking, who he said at one stage should be granted discretionary leave, or should have a discretionary leave decision made at the same time as the conclusive grounds decision. Now that is a different case altogether. It's actually a variant of the case in JP about the order in which decisions should be made. And we can entirely see that there may, in theory, be cases where somebody has a positive conclusive grounds decision and they may have to wait a while for their asylum decision, but in the interim, there is something that requires a decision to be made on discretionary leave as a victim of trafficking. Post JP, the policy provides for that possibility. That is already there. And what we urge the court to focus on is the claim that was actually made to Mr. Justice Linden.
I'm not misunderstood. I didn't think Mr. Butler was trying to broaden his claim in that way. He was responding to an exploration of the kind you inevitably get when we're looking carefully at the document, particularly of the first bullet point on that page we've spent so much time looking at, where exactly that was left, whose case it helped. I don't think he was changing his case.
Well, if he wasn't, then I apologise for having misunderstood. However, I do ask to make clear what the case was that we were having to meet before Mr. Justice Linden, and the framework of the complaint that we make to this court in this appeal.
I mean, the order made by Mr. Justice Linden, because just because someone puts a case one way doesn't mean a judge accepts it, was to quash the decision of the 17th of August 2020 and to grant a declaration that the policy was to be made in accordance with 14(1)(a). The quashing is paragraph 2 of the order, and the declaration is paragraph 1 of the declaration.
Yes, but that is, you see from paragraph 2, the second declaration,
Yeah.
the basis is that the statutory protected stay of a confirmed victim, pending the resolution of asylum claim made by them, based on fear of being re-trafficked, is capable of constituting a stay. So that reflects the way that it was being argued before Mr. Justice Linden.
And as I understood it or misunderstood it before us. I mean, what they say in KTT's position is, I have a fear of being re-trafficked. I've asked for asylum on that basis. You refused it. I'm challenging that, but I need to stay here.
Well, in fact, in many cases that will actually be you haven't yet decided the asylum claim. And the fact of the asylum claim, the fact I'm making asylum claim on this basis, is the reason why I should be entitled to discretionary leave. That's the claim.
Well, but until it's determined, then there must be a risk of persecution or re-trafficking in the overseas state, which means that it would be necessary under 14(1)(a).
We respectfully disagree with that. Whether or not there's a risk of re-trafficking is a fact that has yet to be definitively found at this stage. There may or may not be, but it's an undetermined fact. And we respectfully say that the analysis that my learned friend puts on it, which is to say that there is statutorily a risk of re-trafficking at this stage, puts it too high. There is the position that that fact is undetermined triggers a statutory protection against removal. But it does not say anything about whether it is or is not regarded as a fact by the statute.
Yes, but you raised two arguments in opening, which Mr. Butler rebutted, legitimately within, as I understand it, the grounds of appeal and indeed the decision of Mr. Justice Tendon. You said first the construction of the article was wrong, and you said if it's not wrong, this is talking about permanent leave to remain. And Mr. Butler's answer to that, talking about long-term leave to remain, forgive me for the terminology, but it's talking about a long-term, after all the applications have been dealt with, then you should have a renewable leave to remain under Article 14. His response to that was, it specifically says in Article 14(5) that it is without prejudice to any asylum application, which gives the clear indication that it's not about asylum, that it doesn't matter if there's an asylum application, that you still have to consider whether to give leave under Article 14. And that, as I understand it, is the point you've got to answer. And that's entirely within the ambit of what Mr. Justice Linden was talking about.
Yes, I'm sorry, I'm not saying that learned friends abandoned his case.
No.
But, or abandoned the case below. Sorry, if I've given that impression, that's not what I intended to say. But what I'm asking the court to keep clear in its mind is what was the case that we were addressing and having to respond to, and the situation which is being cited for the relief being sought.
Robin, if you're going to say the way in which the case was put, could you please look at the last paragraph on 299?
I'm asked to show the court the last paragraph on 299.
Of what?
Sorry, core bundle 299. Which quotes from the Scoven argument.
A note.
No?
It was a note.
A note on. Yes, sorry, it's a post-hearing note.
Yeah.
But the reason for identifying this is because we said in our skeleton argument that the problem, one of the problems with the KTT's claim is that it's a sort of bootstraps argument. I'm claiming leave to remain via asylum, and for that reason, I claim leave to remain through this policy. if the claim for leave under the policy is of a different kind, which is I have some more substantive need for leave, then the policy already provides for that. But that was not the way in which it was, as we understand it, being put. So that's the framework. It is not the case that the statutes about asylum claims provide that the person is to be treated as at risk of re-trafficking for all purposes. Can I make a number of discrete points in response to reply to my learned friend's submissions? First of all, there is the point that we make about the oddity of the limitation to trafficking-related claims for asylum. It's odd, not least because it's my learned friend who's contending for a narrow scope for this, and I'm saying that's illogical. But the reason why we are taking these positions is because the wider the category of claimant who can make use of learned friend's argument, if it's right, the greater the disparity between the treatment of victims of trafficking and asylum seekers who are not victims of trafficking, but who may have suffered equally. The limitation, we said it was self-imposed limitation. Learned friend says it comes from P.K. Garner. The limitation is not only illogical for that consequence, but it is also conceptually and practically difficult to operate. Learned friend's submissions posited an unconnected medical condition, let's say unconnected entirely to the trafficking, and said, well, that wouldn't count. But conceptually, the person is a person. If he has a medical condition, he may feel the effects of that medical condition more acutely because of his trafficking experiences. Does that make his medical condition or the consequences of his medical condition a trafficking-related problem that qualifies him, or does he fall outside the limitation that learned friend suggests? The reality is that any victim of trafficking is going to argue that anything that they suffer is exacerbated by their experiences. And so, conceptually, it's going to be impossible to operate this distinction. In practical terms, I think I've already made this point, it's actually quite resource intensive to require the Secretary of State to investigate the asylum claim and its contents before deciding whether or not the limitation can be applied so that the person doesn't qualify. That is either going to be liable to gum up the system further or lead to, in fact, everybody being allowed that, notwithstanding learned friend's purported limitation on who can take the benefit of it. The second point is this. Learned friend made a point about, in theory, under the strict terms of the Convention, somebody who does not have a resident permit being entitled only to emergency medical treatment. It's a hypothetical so far as the UK is concerned, but we respectfully say that what is liable to be the case in many, if not most, if not all, other signatory states to the Convention is something along the lines of what would happen here. Supposing you had a person who was a victim of trafficking, and he was going to remain here for a period, and he needs non-emergency medical treatment, and he doesn't qualify for it under ECAT. Is he actually just going to be left bereft of medical treatment because ECAT doesn't give him the right? The answer to that is surely no. Within the UK system, he would have other things to call on. I don't know what DHSC policies there might be, but he may be able to seek medical treatment under them. He may have legal complaints to make if he's not treated for something he needs to be treated for while he's here and doesn't need to go home. So the idea that somebody who is here and does not get a residence permit is going to suffer because of an absence of non-emergency medical care that we say is fanciful. The next series of points was the 8 points about construction of ECAT. Can I just pick out the ones that I need to deal with expressly? First of all, there is a point that Lord has already been put to me a few minutes ago about the permanence, longer term, whatever. Can I make clear, this is not a question, but the way we say that ECAT is intended to be read and is intended to have effect is not a question purely of time. So it's not trying to measure whether it's days, weeks or months. It's the character of the need for leave which is important. But that is why one can distinguish between what one might call interim leave, that's a word used by Mr. Justice Mostyn, that allows you or bridges the period while you're waiting for another decision, in KTT's case for a definitive asylum decision. That is to be contrasted with other types of leave for which I've used the adjectives longer term or substantive, because that's an adjective that describes what's in the policy, which are of a different character. You have some substantive need for leave, not just one that tides you over to the next stage of the process. And that is what we respectfully say ECAT must be getting at when you look at Article 14 in its context, within its structure, and look at the procedure that Article 14, the procedure that ECAT contemplates for dealing with victims of trafficking. It does not, we respectfully say, contemplate a bootstraps form of leave, which is what KTT is seeking. I need to deal with Article 14.5. If I could please ask the court to turn that up. Page 575, Authorities Bundle 2. We respectfully say that this does not assist learned friends' submissions because it is on this point entirely neutral. 14.5 simply makes the point that ECAT and the asylum system are two systems that run in parallel, and one should not prejudice the other. That's an easy point to make from that document alone. But I did briefly show the court an example, a reported example, of something that might not comply with 14.5. This is Policy Bundle 4, page 1477.
Sorry, 1477. Thank you.
Paragraph 93 of the 10th Greta report. Halfway through that paragraph, there's a reference to a project, REST, which mentions that there are situations in other countries in which residence permits based on the status of being trafficked are withdrawn once the person concerned applies for asylum. And that would seem to be at least in tension with 14.5. And then if you go over to the next page, paragraph 94, in Norway, recovery and reflection period is incompatible with an asylum procedure. When a victim of trafficking applies for asylum after having been granted a recovery and reflection period, he might lose certain entitlements such as a right to work. And obviously those countries aren't here to speak for themselves or even explain whether or not that's correct, but those are situations where you can see that 14.5 might have a bearing. 14.5, all that 14.5 is doing is stressing that there are two parallel systems. It doesn't say that you must give somebody a residence permit if they're claiming asylum. Then can I turn quickly to ground 2? I hope I made clear when I opened exactly what our position is on the difference between the concessions of law and the issues of fact. The points I would make in reply are these. The courts, we accept, have previously struck down parts of these policies for incompatibility with ECAT. But it is clear from looking at the authorities that that has not been done with an analysis of what is required by way of law and fact. Concessions have been set out in pretty general terms without it being entirely clear what is being conceded. There is no policy material that specifically says that the policy, the MSL policy, is designed to implement Article 14. So I think I can continue properly to make the submission that the policy statements being referred to are general and high level. The highest that one can put it is that in I think 2 of the cases, the highest has been shown to the court. In 2 cases, it's been said to the court that there has been an intention to implement Article 14 specifically, plus Mr. Bramley's witness statement in EOG. It will be a matter for this court as to whether or not I have satisfied the test for setting aside Mr. Justice Linden's finding of fact on that, but that is a territory in which we are. And for all the great references to policy statements on analysis, there is nothing, we say, of sufficient specificity. And I think the very final point is this. Learned friend Mr. Butler said that when the policies were amended from time to time, one would expect to see X, or one would expect to see Y. We respectfully say that that is to impose a presumption when reading policy statements of an express statement of compliance with each and every detail of ECAT, unless it is said otherwise. And the argument that I think I can properly make is that there is no warrant for such a presumption in this context, when the Secretary of State has, in some circumstances, been perfectly able to refer to specific articles when setting out policy, well, setting out her intention when setting out her policy. Now just have a moment. Lords, I'm sorry, I have slightly overreached my time estimate, but unless I can assist any further, those are my submissions in reply.
Thank you very much. We will take time to consider our judgments, hand them down in the usual way. When you get them, please agree any order that follows, and also send us typographical but not other corrections. And can I please make clear the importance of the embargo? When you get the judgment, it is not given to you for any other purpose than for counsel and solicitors to send those corrections and agree the order.
My Lord, I'm sorry to stand up. I just wanted to point out that Mr. Tannen handed up one additional piece of guidance in his reply, which was version 1 of the discretionary leave policy. Could I just say one thing about it to save the need to send an email? So far as we can see, that document is identical to version 2, which is the one that we spent a bit of time looking at, save that the bit at the beginning headed changes from the last version says something understandably different.
changes from the last
So the sequence.
version of this guidance.
So the sequence
Says
is
this is the first iteration of this instruction.
exactly.
Formalises the interim advice. The interim guidance will be archived at the same time as this instruction is published.
Yes. That, as far as we can see, is the only difference between the version that I showed the court and this version.
And there isn't, obviously, because it's a version 1, there isn't a changes since previous versions.
No, that's what.
Oh, I'm
my
sorry, I
lord
hadn't got
asked
it in
me
front
to-
of me.
No, that's what my lord just read. It's a section entitled "Changes from
It
the
says
last."
Oh, I
changes
see.
from the last
It,
version.
it has the heading, but just says this is the first one.
Yes, but it says that it formalises the interim operational guidance, which it now replaces. But I don't make any point about it. I just wanted to flag up what we say about it so that I can let it lie.
Perfect. Thank you very much. We'll rise now.
Right.